Okay, I think we're ready to hear from the appellant. I should have got you before you sat down.
Good morning. My name is Webb Brewer from the Shelby County Bar, and I represent the appellant, Marilee Hurley, in this matter. I would like to reserve 5 minutes of my time.
All right, sir. You may proceed.
Okay. This action was brought by Mrs. Hurley as a petition for declaratory and injunctive relief based upon threats from her Homeowners Association, the Green Shadows Homeowners Association, to issue fines, substantial fines, which were not provided for in the relevant declaration, and to come onto her premises and actually perform the replacement of her roof. The house that's in question was built in 1938, and it was put on the National Register of Historic Places in 1995, I believe it was. The roof that's in question is a concrete tile roof that was original to the house and has architectural significance, so she does not want to have to replace that roof absent some real necessity.
Counsel, the cleaning that was done on the roof, did that restore the roof back to its original color, or is it a different color than the roof was at any previous point? I was a little confused on that.
No, I'm glad you asked that. There was no, there was an accumulation of moss on the roof and probably some dirt, which over time had given the roof a darker appearance. Mrs. Hurley had the roof cleaned, just a simple cleaning, which we contend is routine maintenance for the house and something that needed to be done. Incident to cleaning it, the roof was lighter. That was not the intention of the roof's cleaning. There was no intentional change in the color of the roof. It took on a lighter appearance.
And it had been lighter before, right? I mean, it darkened with the moss and the dirt and the covering, and it became lighter again then with the cleaning?
Yeah, it became lighter and actually more like the original roof to the house. And, you know, it will darken its patina as time passes and there's things that accumulate on the roof. We contend that the governing provision of the declaration that's applicable here is paragraph 16, which, well, the interpretation of 16, paragraph 16 requires prior approval of any improvement or change to the property that's in the development. Paragraph 18 deals with maintenance and routine maintenance, and it imposes a duty on a homeowner to conduct such routine maintenance as is necessary to keep the property in good condition. So We contend that the whole case turns on the interpretation of those two paragraphs. Paragraph 18 does not require prior notice. And it wouldn't logically if one were to cut their grass. That's a change in the appearance of the lot. Or clean a mailbox, or do any number of things, rake leaves. And it would be nonsensical for a homeowner to have to make a request and obtain written approval to carry out those kinds of functions.
Let me ask you, Mr. Brewer, did your client submit a proposed plan to make improvements to both the main structure and the carriage house?
She submitted two proposals, written proposals pursuant to paragraph 18. The first had to
Paragraph
do
18 or
with
16.
an extensive renovation of the interior of the carriage house, the smaller house out back.
Okay.
And there were some things that she wanted to do, some kind of cosmetic things to the main house. That plan was submitted in 2018. It was later withdrawn. She never acted upon that. In 2020...
Let me ask you, so I want to be clear about this.
Okay.
So in the original plan that was submitted, it did involve changing the roof of the main house. Is that
Yeah.
accurate or not?
That original plan is not in the court's record, and whether or not there was a specific reference to changing the main roof is unclear from the record, to be quite frank.
So it's not in the record?
It's not in the record, no.
All right, and you said there was a subsequent plan submitted, is that right?
That's correct.
And it included only the carriage house?
It was pertaining only to the carriage house.
And did you get approval from the Architectural Committee of the Homeowners Association to carry out the revised or second plan?
Well, that's a little bit of a hard to answer question. There was correspondence. The plan that she submitted is in the record, and it pertained only to the carriage house. There was no reference to replacing the main house roof. There was
And
correspondence.
was there an approval of the second plan?
Well, there was a correspondence from Richard Fisher. There was an affidavit from Mr. Fisher and an attached correspondence, which was a proposed agreement. And in it said something about, we understand that the roof of the main house will also be replaced. That was not responded to. It was addressed to Mrs. Hurley's contractor, and it was not responded to except that he made a technical remark about the shingles, or the precise shingle that would be used on the carriage house.
Counsel, the work proceeded, though, on the carriage house, though, with the 2020 approval, right? I mean, the carriage house roof was modified, changed, whatever, as approved under the proposal under 2020, right?
That's correct.
And isn't that essentially an acceptance of the condition of you've got to change the main house roof also by going ahead with the carriage house?
Well, we don't believe so, and we also would contend there's an issue of agency here. Mrs. Hurley, in her declaration, has denied that her agent, who was her then contractor, had the authority to do that. The HOA has raised an issue of apparent authority, but it's just not fleshed out well enough in the state of the record at the summary judgment hearing to... What
facts were actually before the trial court judge with regard to the issue of apparent agency? And what's established in terms of the facts in the record rather than assertions of the parties with regard to that issue? What facts would the trial judge have had before the trial judge to make a determination about a parent agency in this case?
Well, that's just it. Most of the argument had focused, and most of the proof in the record had focused on this issue of whether their initial, the HOA's initial action was contending that she was required to seek permission to clean the roof. This issue about that there being a prior condition that the roof of the main house be replaced had come up later, and it was really not very well developed. Now, one thing that was in the record that is important, she learned after, she initially thought that both roofs were leaking and would have to be replaced. She came to learn through a roofing expert that there was nothing wrong with the concrete tile roof on the main house. So that changed everything. She initially thought she needed to replace the main house roof, and then came to learn that she did not at all. I see my time's up.
Thank you, sir. You've used your original time. You got your rebuttal time.
Oh, thank you.
Morning, Your Honors. My name is Peter Baskine. I'm from the Memphis Bar, and I here representing the HOA in this matter. You know, what we have here, I think, is really a pretty basic HOA enforcement matter. And unfortunately, I think we're lucky in one respect in that as we've gone through the briefing, particularly into the reply, the issues here have somewhat crystallized. But let me talk about a few facts before we sort of get a little bit deeper into where we are. Everybody agrees that, back before COVID, Ms. Hurley's house was in grave need of attention, particularly the carriage house. There were some attempts by Ms. Hurley to blame the degradation of the home upon the association. There are no facts in the record about that. And now we're sort of getting down to the nub of things. In 2018, she hires her contractor, a man named Mr. Day, to present a, quote, comprehensive plan. Now, as we talked about a minute ago, Ms. Hurley has argued that he does not speak for her, and I believe Judge Usman was asking about this, if there's anything in the record relative to his apparent or actual authority. On page 228 of the record, Ms. Hurley is saying, I submitted a comprehensive renovation plan to the association that was prepared by my then contractor, that's Mr. Day. And it was submitted by Mr. Day to the association.
Counsel, is that in reference to the 2018 plan?
That's the 2018 plan, yes, sir.
It seems to me that the two sides in this case are, one, you're looking at this as the 2018 and 2020 as all part of one plan, essentially.
I'm not sure I necessarily agree with that.
All right, then how did the 2018 facts matter with regard to 2020?
Well, the 2020 plan, there's nothing in the record saying the 2020 plan was ever approved. Now, what we have in 2018 are these emails going back. You can look at the record. These are on page 170 and 173. We have emails going back and forth between Mr. Fisher, who's on the ARC, and Mr. Day about what is required to get this done. And that's where they're talking about making sure that the two roofs have the same kind of shingles. It was going to be a gray shingle. The 2020 plan, which is the one that Mr. Brewer is sort of hanging his hat on, there is nothing in the record that says it was approved. In fact, there's the opposite. Again, if you go through the record, you'll see some emails from, among other people, Joyce Bianca, who is the the professional manager for the association, saying, no, you got to fix the other roof. Because after we had the whitewashing, then the roofs didn't match. And there's an important point here. One of the hallmarks for what the HOA is supposed to do is to maintain architectural cohesiveness across the entire neighborhood. It's a pretty small neighborhood. I think it's 31 homes. And Ms. Hurley's house is significantly different. Now, Your Honor, you asked Mr. Brewer about whether or not what we got after the cleaning was the original color of the roof. I don't know the answer to that, and there's nothing in the record about it.
Isn't that problematic in terms of asserting change? And if we're talking about a roof that has been changed, if all that's being done is a restoration of the roof that was, that doesn't sound a lot like change.
Well, if we're talking about an historic roof that goes back to the 1930s, I don't know that it was ever anything other than dark. I just don't know that. And opposing counsel is taking as a given that this is returning it to its previous condition. But let's sort of set that aside for a moment. It's not an issue of it going from being dark to being light. It's an issue of it going from being dark to being, what's the term that we have? Blotchy and checked. It's not a continuous color that is dark or light or anything. In fact, if you look at the briefing, I think there's actually some pictures of what the roof looked like after the change. And to be fair with the court, at the trial court level, those were in color and they're sort of they're easier to read. But if you look at the ones we have here, you can kind of see it's not a sort of cohesive color. And what came up after it was done, and again, this is in the record, the association found it to be unacceptable, and this is important, not cohesive with the rest of the neighborhood.
Let me ask you, were there any other houses in the neighborhood with concrete tile roofs?
No, sir.
So it was never going to be the same as other houses in the neighborhood because no other houses had that type of roof, right?
No other houses had a concrete roof, no, sir. And I believe that's like a fairly old architectural feature. But all the other homes have dark roofs. So it is important to the association to have all the houses match universally throughout the neighborhood. And by whitewashing or doing whatever was done to this roof, it ended up being significantly different than the rest of the neighborhood.
But counsel, and that the opportunity for the HOA to act is related to change, right? I mean, and so if she had preserved her roof in good condition, and you could not have required, the HOA could not have required her to change her roof to a dark roof, could they?
No. If it had been light and nothing else was going on, but I think we're missing a point. Remember, there was a comprehensive plan to update the property. Ms. Hurley has called it a comprehensive plan. As part of that comprehensive plan, the roof of the main house was to match the roof of the carriage house. Again, we're looking for cohesiveness here.
Which plan are we proceeding under, the 2018 plan or the 2020 plan?
2020 plan was never approved. And this is problematic more for Ms. Hurley than it is for anybody else. Remember, she has to have written approval from the association to make any changes or improvements. So unless something was approved, and what I'm getting from opposing counsel throughout this case is that none of this was ever approved, well, that's a much larger problem for Ms. Hurley. But ultimately, before any improvement or change is made, she has to seek approval. And it's as if, Your Honor, she knew that, because we know in the record at one point she asked for permission to make sort of a test change, which was granted. But instead of making the small test change, she whitewashed the entire roof, and we got the blotchy and checked appearance that we got. So what Ms. Hurley is sort of trying to get this court to understand is that she can make whatever sort of changes she wants, and the association has to live with it, and that's not true. And this notion that it's mere maintenance is misapplied. If I were to engage in maintenance on my home and get a power washer and take off my paint, and it changes the fundamental color of the house, that's a change that would require an association approval. If I lived in an HOA, I don't.
But we have no indication of what the original color was here, what the color was. Maybe it was blotchy for however long on this house. Maybe it was blotchy in whenever the covenants and restrictions first came into effect with regard to this property. The record doesn't include any information about its earlier condition, does it?
It does not, but again, I think that's more problematic for Ms. Hurley than it is for us. And you're correct, the HOA was formed, I think, in 1986. It's a fairly old HOA. I can't tell you what the roof looked like back in 1940 or 1950. I have no idea.
Isn't that a problem in terms of granting summary judgment in this case, based upon change? If we have no idea what the roof was at the time the house became subject to the conditions of it couldn't be changed without approval? I mean, if in 1986 it's a blotchy roof, then restoring it to being a blotchy roof is not a change, or doesn't seem like a change.
I have nothing in the record to tell me what it looked like in 1986. But the same applies to Ms. Hurley. There is nothing in the record to say that in 1986 it was anything other than dark. In fact, Mr. Brewer was talking about, well, over time you may get more moss growing and it becomes dark, and I don't know about that. There's nothing in the record about it. But he is implying that this is a long-term project that will sort of, develop a patina over time. I don't know that.
It seems like there are a lot of facts that we're missing here, and that brings me back to why is this an appropriate summary judgment case? And there's a lot we do not know about the condition of this roof. In terms of the agreements, I thought we were operating under the 2020 agreement, but it sounds like the 2018 may be the operational agreement. And
well, I can tell you the emails that you can see in the record are from 2018.
so, and isn't this a matter that really needs to go back for additional factual development?
I certainly don't think so, because the chancellor correctly concluded that Ms. Hurley had made a fundamental change to the look of her house. But it didn't stop there. The chancellor also concluded that Ms. Hurley had failed to follow her own comprehensive plan, which would require a new roof on both of the houses. In briefing, opposing...
So which plan did the chancellor say she was supposed to follow?
I don't think the chancellor actually broke out which it was, but the chancellor did talk about...
And how can we line those up and see if the court was correct?
Well, if in the order, the chancellor is saying that two things happened. That she made this fundamental change to the look of the house, and she had failed to follow the comprehensive plan to put the new roof on. Of course, that goes back to 2018. But there's nothing that is in the record that says this 2020 plan that Ms. Hurley is hanging her hat on, where she was only doing things to the carriage house, was ever approved. Again, the opposite is true. We have emails from the association to Ms. Hurley saying that she needs to go ahead and put on the new roof.
Counsel, you say, of course, but and the apparent authority issue seems like it's more closely related to the 2020 plan rather than the 2018 plan. I mean, she had conferred actual authority in 2018 for Mr. Day to proceed on her behalf, and the 2020 plan, I take it, is the one where, or do we have an apparent authority issue with regard to the 2018 plan also?
Well, under no occasion, Your Honor, was Ms. Hurley ever discussing things directly with the association. She was always going through her contractor. So whether he had actual authority is almost beside the point. Mr. Day was speaking directly for Ms. Hurley really at all times. So I don't know what else the association is to expect. If Ms. Hurley is having Mr. Day speak for her, I mean, that's apparent authority. So if Mr. Day says we're going to put new roofs on both houses, we're going to put new roofs on both houses, or at least that's how it should be.
You don't dispute that in 2020, there was a submission for a revised plan?
I do not dispute that.
And did the homeowners association act on the revised plan?
I don't have any specific documentation saying you've been denied. But we do have those emails in the record from, again, Joyce Bianca, the professional manager, saying you're going to have to re-roof.
And that's in the record? There's an
It
email?
is. I may even actually have it. It may actually be in the brief, if nothing else. It's in the summary. I'm looking for it. Yes. In my brief, it is on page 12.
And there's no mention of what work needs to be done in the main house, other than this email from this party saying you still got to do the work on the main house? Is that right?
What it says in relevant part, the current state of the roof on the main house is unacceptable, and the board reserves the right to take any and all further legal action until your noncompliance is fully remedied. It also talks specifically about Mr. Day, and the shingles were subsequent, that Mr. Day was her representative, and the shingles were approved by the ARC for both houses. And apparently they were purchased at some point too. And again, that's on page 12 of the briefing. It was also part of the summary judgment.
Let me ask you about this question about the dismissal of the deck action, because all the homeowners weren't joined.
It's an interesting academic question.
I don't know that I think it's that interesting.
Well, you asked about it.
I did, but I wanted to make sure I understood what the trial court did.
What the trial court did is, Ms. Hurley is trying to define the outer boundaries of the ARC and the association. If the deck action had been granted as was requested, that would fundamentally change the power of the ARC and the relationship between the members of the association and its HOA. And based upon that, the chancellor, I believe correctly, concluded that in his discretion, those were necessary parties because it would change a contractual relationship between the association and those folks. And as we know from case law, when we're talking about deck actions, a trial court judge has discretion to determine who he or she believes are necessary parties, and Chancellor Jenkins did that.
So are all the homeowners in that association members of the HOA?
They are members of the HOA, but I'm not sure that's necessarily a relevant question. The HOA...
But it's my question.
I understand, but the HOA does not speak for each individual homeowner. What Ms. Hurley was attempting to do was to change that relationship between the HOA and the homeowners. And that is why the chancellor, again, I think correctly concluded that the homeowners had to be joined. And that goes back to the Brock versus Ike question.
Which necessarily excludes the question of if you've got an HOA.
Well, you're correct. In Brock versus Ike, there was no HOA. It is my position, you may or may not disagree, that whether or not there's an HOA is beside the point, because we are still fundamentally changing the contractual relationship between, in this case, the HOA and its membership.
Counsel, with regard to lawsuits involving HOAs, anytime you have a question of whether an HOA can act or not, that issue seems to be relevant in terms of scope of authority and power. And are we essentially saying that necessary parties in any action involving HOAs are going to have to include all members?
No, sir. And this case may be a little bit different in that Ms. Hurley is trying to, again, establish the outer boundaries of HOA authority. In my law firm, we do HOA enforcement actions all the time. And it's usually a straight issue of, here's what the document says you had to do, you didn't do it, you're liable. This is a bit different. She is asking for a change or deep analysis of the HOA's authority, and that is fundamentally different.
All right, thank you.
Thank you, Your Honors. I ran a little over.
All right. I believe you have 5 minutes, sir.
All right, thank you. I would like to follow up on the discussion that the court initiated involving the trial court's ruling that it didn't have subject matter jurisdiction because all of the homeowners who were bound by the declaration were not joined as parties. That was based upon this court's relatively recent decision in Brock v. Ike. And there's a couple of very big distinctions that exist there. One is that there was a declaration but not a homeowners association in the Brock case, which there is certainly here, obviously, and there's plenty of evidence of action by the Architectural Review Committee. I think the trial court confuses members or people that are bound by the contract and those that have a justiciable issue in this controversy. And this controversy involves whether washing the concrete tile roof was a change or not an improvement or change or routine maintenance. There's no indication that there is any other homeowner, and as the court pointed out, there's no other concrete tile roof in the development. So this issue, others just do not have a justiciable issue or a justiciable concern about the outcome of this case. And it's body of law going back for years and years that courts cannot issue advisory opinions. So I believe that others that might, I don't know that any other, I doubt that any other owner would want to be involved in the litigation. But even if they did, unless they have a justiciable interest in the outcome of the case, they are not proper parties, and to cross over that threshold would leave the court in a position of issuing an advisory opinion, which
Counsel,
I think
under the covenants restrictions, can another homeowner bring an action? And so somebody's in non-compliance, you're not the HOA, but you're another neighbor. Can you bring an action under these restrictions and covenants?
yes.
And does that make it a justiciable question in terms of if somebody litigating on, I don't like the way the tile roof or the concrete roof looks on the house, and have a right to enforce that restriction?
I believe that any homeowner has a right, and I can't cite the paragraph right this moment, to bring an action to enforce, and this is the language, to enforce the covenants and restrictions in the declaration. There's no indication, however, though, that anyone has expressed an interest in that. They could, if they wanted to, they could bring an action on behalf of, well, on their own behalf rather than on behalf of the Homeowners Association. But I think under the proper interpretation of the Brock case, I just don't believe that the chancellor was correct. I think he's misinterpreted the Brock case. And I think what that would suggest for future precedents, there are a lot of homeowners associations with hundreds of members, and it would become quite burdensome to have to include all of those people in any action, for a plaintiff to join all of those people at parties. And in other kinds of cases involving a contract, there could be thousands and thousands of people who had signed the same contract, and it would be just unworkable to join all of those people as parties to this litigation. I see my time's
Yeah,
up.
let me ask you, is the attorney fee award an issue in this case, Mr. Brewer? The attorney fee award, is that an issue in this
Well,
appeal?
it is in the sense that we believe that the court erred in granting summary judgment to the HOA, which would trigger the provision in the declaration that entitles it to attorney's fees. So we're asking the court to reverse the first finding. The court made a bit of a confusing decision because it talked about that it was a change, cleaning the roof, but it also talked about it was a part of an agreement, a prior agreement, that I've argued that there was not enough evidence in the record to justify.
But you don't include that as a stated issue, nor do I find it in your table of contents, or even in your argument in your brief about the attorney fees.
Well, we didn't raise an issue and don't really as to the reasonableness of fees if fees were appropriate. But we do strongly argue that they were not a prevailing party, or that they should not have been a prevailing party,
Okay.
so that they're not entitled to attorney's fees. Our quarrel is more with their entitlement to attorney's fees than the amount of fees,
Okay.
if that answers.
Thank you.
All right, thank you.
Thank you, counsel. We appreciate your argument. We will take this matter under advisement, review the record, and endeavor to get you an opinion at the earliest possible time.
Thank you, Your Honor.
Thank you. You may be excused.
Drive carefully in the snow.
Hopefully, there's none out there now.